Hello everyone and welcome to Course 5. My name is Danielle Burrard and I'm a Senior Counsel in Walker's Employment Team. I'll be presenting today along with my colleague Sarah Ash, a Group Partner and Head of the Employment Team at Walker's, Karen Blanchford, who's here on behalf of Equality Guernsey, and Nikki Ioannidou-Chotis from Guernsey Employment Trust. Today we are going to be covering two main things. The first is the duty to make reasonable adjustments. We're going to be looking at when it applies and looking at some examples. And then we'll look at accessibility action plans. What are they? Who should prepare one? And what should they include? So first of all, what is the duty to make reasonable adjustments? Well, it is a duty to take positive steps to remove the barriers that people with disabilities face because of their disability. And the aim behind it is to ensure that people with disabilities have access to the same opportunities and the same services, so far as is possible, as people who are not disabled. Before we get into the detail, let's have a quick look at the benefits of making reasonable adjustments. It's a legal duty under the new ordinance to make reasonable adjustments, and therefore doing so will reduce your legal risk. But that's not the only benefit. For example, being prepared to make reasonable adjustments widens the pool of potential candidates and helps attract employees and keep employees in employment. If an employee is put at a disadvantage as a result of their disability, this can impact their productivity and lead to higher levels of absence. And therefore, being prepared to make adjustments can help improve productivity and reduce absence levels. And finally, if you're a service provider, then making adjustments can increase your pool of potential service users, which can only be a good thing. Who is under a duty to make reasonable adjustments? Well, pretty much everyone who has obligations under the new ordinance is under the duty to make reasonable adjustments. However, the precise nature of the duty differs depending on what type of duty holder you are. And we're going to come on to talk more about this in a moment. There are two main duties that form part of this duty to make reasonable adjustments. The first applies to everyone who's listed on the previous slide, and that's a duty to make reasonable adjustments where a specific person is placed at a substantial disadvantage due to their disability. As well as this, there is an additional proactive duty to make reasonable adjustments that applies to service providers, schools, and education providers. And they must consider and make reasonable adjustments for potential students and service users. Before we come on to look at exactly what those duties require in practice, let's just look quickly at when the legislation will come into force. So in most cases, it will come into force on the 1st of October 2023, but some of the duties will be delayed. In particular, there will be no duties on education providers before the 1st of September 2025 at the earliest. And any requirement to make changes to physical features of premises won't come into effect before the 1st of October 2028. So when does a duty to make reasonable adjustments arise? Well, there's three different scenarios. The first one is where a provision, criterion or practice puts a disabled person at a substantial disadvantage in comparison with people who are not disabled. And where this applies, the duty holder must take reasonable steps to avoid the disadvantage. So let's break down those parts of that duty and look at when they would apply in practice. So what is a provision, criterion or practice? Well, anyone who's come along to course 2, where we talked about the different types of discrimination, might be familiar with this concept from when we went through the duty, went through indirect discrimination as a concept. Provision, criterion or practice is not defined in the new ordinance, but it's the same terminology that's used in British and Jersey discrimination laws. And we expect that it's going to be interpreted quite widely to include any kind of formal or informal policies, rules, practices or arrangements. And it could potentially also include one-off decisions if they are indicative of how the duty holder would decide similar situations in future. That's provision, criterion or practice. But as you'll recall, that provision, criterion or practice needs to place a disabled person at a substantial disadvantage. So what does that mean? The ordinance says that substantial disadvantage means a disadvantage that is more than minor or trivial. So that's obviously quite a low threshold. And it's also important to remember that unlike the concept of indirect discrimination, there's no need to show that others with the same disability would also be put at a substantial disadvantage by the provision, criterion or practice in question. Let's look at some examples of when the duty to make reasonable adjustments might arise. So, for example, in a redundancy exercise, one of the employees who is placed at risk of redundancy has a disability which impacts their ability to concentrate. In those situations, it may be a reasonable adjustment to allow additional breaks in the redundancy consultation meetings. Or if a club's membership process is by way of an online form and a particular disabled person is unable to complete that form, either because they have a learning disability, which means they're unable to do so, or if they have a visual impairment, for example, and they need specialist voice recognition software, which is not compatible with the form. In those situations, it may be a reasonable adjustment to enable them to apply for membership in a different way. Other examples could include making changes to your recruitment practices if you're an employer, either doing your interviews in a different format or different location, for example, or in an accommodation provider scenario, it might be making an adjustment to allow tenants who have service dogs. Or in a school context, if there was a student who used a wheelchair who needed to be on the ground floor, a reasonable adjustment may be to switch the location of the classrooms so that that student can learn on the ground floor. So that's the first situation in which a duty to make reasonable adjustments applies. The second situation is where a physical feature of premises puts a disabled person at a substantial disadvantage in comparison with those who are not disabled. And once again, the duty is to take reasonable steps to avoid the disadvantage. Now, just a couple of points to note. The first is that the nature of this duty to make physical changes to premises differs for accommodation providers, and we'll come on later to talk about those differences. The other thing to note, as I mentioned earlier, is that this duty will not come into effect before the 1st of October 2028. So what is a physical feature? Well, it's defined in the ordinance as a feature arising from the design or construction of a building, or a feature of an approach to, exit from or access to a building, or a fixture or fitting in or on premises. So it will include all the types of things on this slide: steps, stairways, parking areas, building entrances and exits, etc. Let's look at some examples of potential adjustments in this situation to number 2. So it could include, for example, moving an employee's desk to a different location, perhaps a quieter location, or one that's more accessible, depending on their specific needs. In relation to clubs and associations, an example could be widening a parking space for a disabled club member who needs more room to get in and out of their car. One example in the school and education providers context, which I saw in my own children's school at the end of last term, I noticed that the caretaker was painting additional white lines in the playground near to where the playground met the parking area. And I got talking to him, and he explained that there was a student with a visual impairment starting school the following year. And they were painting additional markings on the playground for safety reasons, so that it was clear where the playground ended and the car park began. I'm now going to pass on to Sarah to talk about the third situation in which a duty to make reasonable adjustments can arise.
Thanks, Danielle. I'm going to come on now and talk about a third scenario and cover auxiliary aids. Now, there's a duty to make reasonable adjustments where a disabled person would, but for the provision of an auxiliary aid, be put at a substantial disadvantage in comparison with those who are not disabled, and the duty holder must take reasonable steps to provide the auxiliary aid. So let's look now in a little bit more detail about what auxiliary aids are. So, what is an auxiliary aid? It's equipment or a service that is used by a disabled person and which compensates for or removes any disadvantage or inequality connected with the disability. So, for example, it might include a rise and fall desk or specialist software for visually impaired employees. If a person would ordinarily have a piece of equipment, however, for example, a white stick or a wheelchair, which is not specific to the workplace or to a particular service, the employer or service provider would not be expected to take on responsibility for providing this. We now have a short video to show you. GET, the Guernsey Employment Trust, provides supported employment services to support disabled individuals into employment. And this video shows an example of a service which can sometimes amount to an auxiliary aid, and this video will explain more.
The benefits of working with a supported employment agency, which could be Guernsey Employment Trust or it could be others on island that also offer that service, is that you'd really know the client and you would know that the job that you've put them in is a good match for them. You'd be able to do the appropriate health and safety checks for that person. You'd be able to communicate any reasonable adjustments that they might need. Having a support worker there, you're of support to both the client and also the employer. And by that, you could be helping the client learn the job or helping them in social situations. And for the employer, you might be able to communicate with them and explain what the client needs. You can also offer training to the other colleagues. So some people find it difficult or don't really know what to say when someone comes working with them that has a disability, and that training can provide reassurance, and which would be so beneficial to both the client and the employer and the colleagues.
I'm now going to come on and cover knowledge of disability. So the duties described in this section will not apply unless the duty holder knows or could reasonably be expected to know that the person has a disability. However, failing to act on warning signs and to investigate further is unlikely to absolve the duty holder of responsibility. So let's take an employment example now. So if an employee's performance worsens without any clear reason why, and the employer is considering performance management, they should consider whether the performance issues may be due to an underlying medical condition. Failing to do so puts them at risk of a claim for failure to make reasonable adjustments, should the performance issues be connected to a disability. So it's important that in these types of situations, the duty holder can't just stick their head in the sand, essentially, and not ask the obvious questions. In other words, in the hope that this avoids any liability under the ordinance. And this example also demonstrates the point that was mentioned earlier about how, although it is sometimes described as a reactive duty in the employment context, you cannot sit back and wait until specific adjustments are requested before having to consider your duty to make reasonable adjustments. So I'm now going to move on and we'll look at what the duty holder needs to do. So, in these types of situations, it's really important to consult with the disabled person to ask their view as to what steps would avoid the disadvantage. This could give you it's some really useful information to work with and actually help you understand better the needs of that disabled person. In addition, it may be appropriate to consult with other persons as the duty holder considers appropriate, for example, occupational health or a medical expert relevant to the disabled person's condition. You may also want to take reasonable steps to avoid the disadvantage or provide an auxiliary aid. It's important to do this. And if the duty holder decides that a requested adjustment is not reasonable, the duty holder should respond to the individual explaining why that's the case. Now, one point to remember here is if you are consulting with others, you will need to consider your data protection obligations. It's also good practice to document your decision and the reasons for it. We now have another short video about the importance of consultation.
I think one of the most important things I'd say is that simple things really can make a big difference, and you don't need to spend lots of money or even lots of time on things. And quite often as well, it's very helpful if you are going to make reasonable adjustments to have open conversations with either, a new employee coming in, or if it's for an existing employee, because quite often they'll have their own ideas, and it takes a lot of time out of the business kind of coming up with things themselves, because one of the most important things is giving someone what they need, and they know what they need better than anybody.
I think people, they will try and help you to the best that they can. They don't always know possibly the correct or the best way to possibly help you, but most of them do try and help in the best way that they can. And then I guess if they don't, you just have to try and sort of explain, well, can you perhaps show me this way? Can you explain it like that? Or can you point that out to me? Yeah, there has been times where they have got things like they'll make something bigger, but like really big, and put it on something like an A3 size sheet of paper, because they think that's going to be helpful, and they really are trying to help, but because they haven't asked for your input of how you want something done, you then kind of think, well, this isn't going to help me.
People come to this with the best intention, hopefully, most do, but I would advise employers to listen to their employee and their employee's advisors. And by advisors, I mean physiotherapists, occupational therapists, the consultant, the doctor, those that know what the future might look like for this person. And I feel that if the employer has a way of doing that, so that they can collect, because to make good decisions, you need good information. And I think there's a danger to assume. So I think if the employer says, look, let's talk to the relevant parties, complete as a group, or individually, whatever it might take, and then we can make a decision about how we tailor the return to work, the type of work that we do for this individual, or any adjustments physically to the building that we might need to make.
I'm now going to move on and cover the proactive duty to make reasonable adjustments. I think the first important point to note here is that the proactive duty only applies in some cases. And as you can see from the first bullet point on the slide, service providers, schools and education providers will have an additional proactive duty to make reasonable adjustments. And this means that they must make reasonable adjustments before this is requested or required by a specific individual. And this applies even if the duty holder is unaware that any of its current service users or students are disabled. Now, the requirement for education providers and schools won't come in before the 1st of September 2025, so they will have more time to consider their proactive obligations, and changes to physical features are not going to be coming into force before the 1st of October 2028. So whilst there isn't that immediate pressure to be thinking about this duty, it really would be good practice to start planning in advance. So, for example, an example of how the proactive duty might work in practice might be printing, for example, printing materials out for customers or pupils and ensuring that this can be done in different fonts, sizes or formats. So when does the proactive duty arise? I'm going to cover 3 different points here. Looking at the first one on the slide, the proactive duty would arise where a provision, criterion or practice, sometimes called a PCP, puts disabled people generally at a substantial disadvantage in comparison with persons who are not disabled. And there might be some examples here of how you might be able to respond in these situations. So, for example, providing services in a different way. So, for example, offering online as well as in-person sessions, offering alternative appointment booking systems or an application process if some people are unable to book online or over the phone, for example. Offering information in alternative formats, as I just mentioned, that would be good practice and inclusive to be able to offer different options when people want to access your services. So phone, email, text, for example. Also, perhaps allowing assistance personnel or animals to accompany the disabled person. Looking at the second example, the proactive duty may arise where a physical feature of premises puts disabled people generally at a substantial disadvantage in comparison with those who are not disabled. So an example here where you may be able to think proactively is putting in handrails for support, clear signs around buildings and entrances and exits or around, for example, a school setting. Also, perhaps considering ramps, access into buildings and possibly automatic doors. The third scenario on the slide is where disabled people generally would, but for the provision of an auxiliary aid, be put at a substantial disadvantage in comparison with those who are not disabled. And some examples here of auxiliary aids that may be helpful might be hearing loops, or providing services at different times or in different ways for disabled people. For example, the co-op's quieter shopping hours, offering home visits maybe, or virtual calls. There are some points to note. So service providers, schools and education providers do not need to predict the needs of every single student or individual who may possibly require their services, but they should be thinking about what disabled people with a range of impairments might reasonably need. The other thing to be aware of is this is a continuing duty. So service providers, schools and education providers should be regularly reviewing the adjustments they are making. It's also important to remember that service providers, schools and education providers are also under the reactive duty that we've covered earlier in this presentation, and that's the reactive duty to make reasonable adjustments should any additional adjustments be required by any particular service user or student. In relation to physical features, the duty is either to take such steps as is reasonable to avoid the disadvantage or to adopt a reasonable alternative method of providing the service. So, for example, A shop probably cannot move all of its produce so that it's accessible to a wheelchair user, but it should implement processes to allow a wheelchair user to access goods placed higher up, for example, to be able to offer up a member of staff to help that shopper. It is important to remember as well, of course, that this duty does not come into force for at least 5 years, but it is best practice to be making these adjustments earlier if possible. And many organisations will already be making these types of adjustments. The other thing, the final bullet point on the slide here to think about, service providers, schools and education providers are not required to fundamentally alter the nature of the services that they provide. So, for example, there would be no obligation on a nightclub to reduce noise to accommodate people who are sensitive to loud noises or who struggle to hear in loud environments. So, if the proactive duty applies, what do you need to do? Well, it's important to consider what adjustments a range of service users and pupils may require and implement those which are reasonable. It may also be appropriate to make temporary adjustments pending more long-term adjustments. You should also consider making an accessibility action plan, but Karen will be covering more about this later. I'm now going to hand over to Nikki, who's going to cover when will an adjustment be reasonable.
Thanks, Sarah. Hello, I'm Nikki Ioannou-Drussiotis, and I work for the Guernsey Employment Trust, and we support disabled and disadvantaged people to prepare for work, to find work and to maintain work, and we work with a lot of businesses. Our involvement in the consortium is to bring this topic to life, as we appreciate that when you look at get into the finer details of the legislation, it can get a bit heavy going. So to bring this topic to life, we have done some videos of real local people giving their practical examples and to help remind us of why this legislation is so important. So in this next video, we're going to introduce you to a few people who will give examples of their adjustments and how these adjustments made a difference for them in the workplace.
So we've done lots of different things. We've got in sit-stand desks for people who have needed them right from the start, or if anybody's been kind of injured or anything throughout their working period. We also have a member of staff who's visually impaired, so we've allowed that person to bring their guide dog in with them. The staff love it, they get to have a dog in the office all the time. But we've also invested in some specialist equipment for that member of staff to kind of just help them a bit with their day-to-day work and make it a bit easier. We've also changed we've delayed some start times for some members of staff if they kind of find it a bit harder to come in that early in the morning. And then we've also as well changed some duties for staff members depending on what their needs were, just to make life a bit easier for them.
A lot of what I do can often be on a commercial building, and I need to survey that building. Now, in the old days, I'd go up ladders into plant rooms, get underneath bits of kit, that type of thing. Right, I still understand what to do. I can still do the technical analysis, but I can't physically get up that ladder and put my head above the ceiling because I'll just fall off. So the clients I work with will often provide me with an engineer, with a ladder and a good pair of eyes, and my camera, and he will help me where I can't get in access to a particular area. So people recognise that you can still contribute, but they just need to be a little bit different about how we do the work.
So certainly in the last employment I was working in, they were very good at making the handouts bigger. So like, for example, if I needed size 14 font, they would do it in that for me. And I was also allocated a laptop, so that was kind of made bigger and everything for me, and my email setup was quite a lot bigger, so that was helpful.
Check out only contracts. Make sure there's a chair available at all times on the checkout, and yeah, I think that's about it.
So in your role at the moment then, you are mainly based on the checkout, so
Yeah.
you're not required to do any
No.
of the shelf stacking?
No.
What about the hours that you work?
I do 12 till 5 at the moment, Monday to Friday.
Are they the standard hours at your workplace, or were they an adjustment for you?
Bit of both really, because Peter said that he needed someone just doing the checkouts and things like that, and but no, I think I'm the only one that's doing 12 till 5 at the moment.
Hopefully you found that video useful. So I'm now tasked to talk to you about reasonableness and what this looks like. So hopefully through what we talked about in sessions 2 and 3 and earlier on today, it will be clear to you now that a failure to make a reasonable adjustment will be a form of discrimination. But what does reasonableness look like? How is it going to be determined? One of the key points is that an adjustment must avoid the disadvantage. It needs to be suitable. It needs to work. So from an employment perspective, an adjustment needs to make a significant enough difference that it allows somebody to get on with their role. It doesn't necessarily need to remove all of the disadvantage, and it doesn't need to be 100% foolproof at the point a decision is made. But as Danielle went into earlier, it's so important that you consult with the disabled person and also anybody in a health profession that would be useful in the consultation process to make sure that the solution that you come up with is suitable and that you continue to review those adjustments to check that they continue to be fit for purpose. In one of the videos, Shelley gives an example of the goodwill of her employer, who provided an adjustment for her in that they gave documents in an A3 format, but they forgot to consult with her. And actually, it wasn't a reasonable adjustment for Shelley because it didn't remove the barrier and make the task easier for her. The last point on this slide said it must not place a disproportionate burden on the duty holder. So that could be a service provider or it could be an employer. An important point to remember is that nowhere in the law will it require an employer to employ or keep employed a disabled person who cannot perform the essential functions of the role, as this would be disproportionate. But this is after the consideration of reasonable adjustments have been made. A good practice tip from me for employers is at the point when you are recruiting staff, take a good look at your person specification and your job description. Make sure that your person specification, the language used, is appropriate to the level you're recruiting to. We see many an employer asking for all colleagues to have excellent communication skills, but the reality is in that role you don't need excellent communication skills. You might just need good communication skills. Also, look at the duties outlined on the job description. Are these still all relevant? Often we see employers, their job descriptions can get longer and longer, but yet there are duties on there that are no longer relevant. But another good practice tip is to divide the job description into essential or core duties versus the non-essential duties, because this will make it easier for you when it comes to determining which duties could be allocated to another member of staff. In one of the previous consortium sessions, actually, a member of the audience gave a really good example of somebody putting in a working from home request. We all know post-COVID that working from home is much easier than it has ever been, because we all bought into that way of working, and a lot of businesses now have the technology to fall back on and staff that are trained to do that. But if the working from home request comes from somebody in a customer facing role, is that reasonable? Well, if their role involves interacting face to face with customers, and that can't be achieved on a telephone or on an online platform, then the likelihood is that's disproportionate. So moving on to my next slide, which is titled Disproportionate Burden, what factors are used to determine this? Well, obviously the cost of the adjustment. So smaller costs, for example, a ergonomic keyboard with wrist support for a colleague with carpal tunnel at a cost of approximately £50 is likely to be reasonable for most businesses, especially if the staff member is expected to use a computer for most of their shift. But larger costs associated with adapting the premises are likely to be considered a disproportionate burden for the smaller organisations over here. But the national and the international organisations that have a base in Guernsey, the cost is likely to be reasonable. The point on practicability refers to how easy the adjustment is, or a time frame around this. So it might be that an adjustment requires a specialised piece of equipment, which is difficult to get on island, and you might need to bring it in. And actually, if you have a project that has a tight time frame on it, but yet and needs to be done soon, and yet the equipment might take several months, in that scenario, it would be classed as disproportionate. With regards to financial and other resources, here it's important to remember that you're looking at the resources of the whole organisation. So from a financial point of view, you would be looking at what money you have as a whole group. So if you have an employee who works for the IT department at Specsavers, you're not looking at the resources of the IT department, you're looking at the whole organisation. Also, when you're looking at support, you're looking at support available in the whole organisation, but also what other support is available in the third sector or statutory support. Impact on others is an important one. So when you're looking at the impact of reasonable adjustments, you really need to see how that adjustment could impact other colleagues or maybe even customers. So if you are going to purchase a piece of equipment or adjust hours, which could impact other people when you need to have an office to cover, you need to look at those things. You also need to look closely at there could be conflicts if an adjustment has already been agreed for another staff member. But it's important to note that adjustments can be really positive. I supported somebody once who'd had a head injury, and I supported him back into the workplace. And he had an induction handbook that he was required to read, which was, to be honest, it was really heavy going. And I supported him to make it more accessible, adding in pictures and removing a lot of the jargon to make it easier for him to understand what was expected of him. And actually, after his induction, the workplace turned around and decided to take on the new, easier version and get rid of their original version. And then the last point on this slide just mentions about considering any other legal constraints that might be to do with planning permission or health and safety law. So moving on to the next slide, we've already talked about it, but just generally larger organisations will be expected to have more resources and to spend more on potential adjustments. But the important thing to remember is that the person that pays is the duty holder and not the disabled person. So disabled people will have equipment that they will ordinarily require. So whether that's a wheelchair, glasses, hearing aids. So clearly those are costs that they're expected to bear, but an adjustment, it is up to the duty holder to pay for that. So that might be, for example, visual software that somebody needs to enable them to work in the workplace. It is reasonable that the employer would pay for that. With regards to cost, When you search on Google, the average cost of reasonable adjustments in the UK differs from website to website. But if you look at People Business, they provide an average figure of £75 per adjustment, whereas ACAS averaged the cost of reasonable adjustments between £250 and £560. From my experience, the best adjustments are often free or very minimal in cost and simple. In the video that you just saw, some of the costs that were outlined in there were a chair, or altered duties, altered hours, assistance on a stepladder, or space for a guide dog. These are really easy to achieve and free or very cheap. The final point on this slide is about access to work. So I want you to know that the states of Guernsey are looking at producing an access to work scheme to complement the legislation. And this will be for smaller businesses for them to apply to when the cost is deemed as a disproportionate burden to them. But yet an additional cost paid by the states of Guernsey would make a significant allowance to allow somebody with a disability to enter the workplace. So watch this space on that scheme, and I'm sure you'll find out more when the details of those have been considered. One point I just wanted to go back to on this slide is when we're talking about the duty on the duty for the service provider or employer, the only exception to this, which Danielle will go into shortly, is some very specific circumstances for landlords when they're required to pay, but Danielle will go into this. So I will now pass on to Danielle.
I mentioned earlier that we would come on to talk about the duty to make reasonable adjustments in the accommodation provider context, and in particular, when there will be a duty to make changes to physical features of premises. And that's what we're going to cover now. There are 3 different duties that you need to be aware of. Firstly, a duty on landlords to carry out minor improvements. And they must do this where the lack of such improvement puts an occupier at a substantial disadvantage in comparison with people who are not disabled. Minor improvements has a specific definition in the ordinance, which is set out on this slide. So as you can see, it's relatively limited in scope. And as with other reasonable adjustments more generally, landlords do not need to make the improvement if doing so would place a disproportionate burden on them. If the landlord is required to carry out an improvement, the tenant must not be required to pay any of the costs. And this duty applies to both commercial and residential landlords, although in relation to residential landlords, it will only apply if it's the occupier's principal place of residence. And then finally, as with all duties to make physical changes to premises, it won't come into force before the 1st of October 2028. The second duty to be aware of is a duty on residential landlords to allow other types of adjustments. And they'll be under a duty to allow a disabled occupier to make reasonable adjustments where the accommodation is the disabled person's principal residence, a physical feature puts the person at a substantial disadvantage, carrying out the work on the property would compensate for or remove the disadvantage, and the work is of a certain type. And in terms of the type of work, it must fall into one of the following categories. It must be either alteration to or the addition of fixtures and fittings. So that would be things such as installing grab rails, perhaps special bathroom or kitchen fittings, stair lifts, that kind of thing. Or alteration or addition to a physical feature connected with the provision of services to the accommodation. So that might be something like moving the location of the fuse box or the stopcock to allow easier access. If the tenant requests any of these changes, then they may be required to pay for some or all of the cost of the work themselves. So that's a significant difference to the general duty to make reasonable adjustments. They may also be required to engage an appropriately qualified tradesperson, and they may be required to restore the property to its original condition at the end of the tenancy. There is then a similar duty on commercial landlords to allow reasonable adjustments to physical features. And again, this will apply where a physical feature of the accommodation puts a disabled tenant or an employee or service user of the tenant at a substantial disadvantage in comparison with people who are not disabled, and where the relevant work would compensate for or remove the disadvantage. Unlike the duty on residential landlords, this is not limited to certain types of work, but the other qualifications that apply to the duty to residential landlords do apply. So the tenant might be required to pay the cost themselves, may be required to engage qualified tradespeople, and may be required to restore the property at the end of the tenancy. So again, examples would include things like handrails, entry ramps, perhaps marking one or more parking spaces as reserved for people with disabilities. And as with all of these duties to make changes to physical features of premises, they won't come into force before 1st of October 2028.
My name's Karen Blanchford, and I'm going to lead you through accessibility, audit and action plans. So what do we mean by accessibility? Accessibility is the design of products, information, devices, basically the environment within which we live, and working out how easy it is to use by a wide section of the community. We're talking about the public and people basically with a disability or impairment. Accessibility is diverse as people are. That means that it isn't the same for everyone, and we need to consider accessibility in its widest context. That includes, although not limited to, web and digital access, print or what we say hard copy accessibility and content, customer service, how we interact and work with others, and then physical accessibility. The legal duty to prepare accessibility action plans only applies to the public sector service providers, public sector schools and education providers. The duty will not come into effect before the 1st of October 2028. That's 5 years after the legislation comes in. The Accessibility Action Plan must be what we say reasonable, adequate and proportionate, taking into account the size, finances and other circumstances around the provider. Although some people are not subject to the legal duty, we are encouraging people to consider preparing an accessibility action plan. It's good practice. It can help to make your premises and services more inclusive and available to more people in the community. It may also help defend claims for failure to make a reasonable adjustment. So what is an accessibility action plan? We've got a couple of examples to show you, and there'll be hyperlinks within the slides. But generally, we're talking about a plan that outlines the steps that you could take as an organisation to prevent and remove barriers and basically improve the accessibility of your services. It may include aims and objectives, actions and timelines, a communication plan, an implementation plan, evaluation and review. We'll give you a couple of examples of these in case studies. So case study 1. People with Disability Australia. It's an organisation, as you've probably guessed, in Australia, and has a really great interactive session online that anybody can use. We found this one of the best examples of how you can do a quick and easy and pretty thorough review. And here are the sections from this case study. Aims and objectives. It really outlines things like why it's important to your organisation that it's more accessible. How will your service incorporate the plan into other organisational plans and strategies, i.e. it doesn't stand alone but is a key part of everything that you do. It also looks at the overarching short and long-term goals and the targets that you should set in relation to access, again making sure that they're integrated. The form that I mentioned is interactive, also has some great examples around actions, timelines and responsibilities. It gives a table in which you can list the issue or the barrier to your services, the action that is required, who will be responsible, and by when. It also gives some great examples of what we call SMART goals, making sure they're specific, measurable, have clear aims, realistic, and are timed. So what about communication? There's a really key part of accessibility plans. The idea is that they're not just put on a shelf. So how will you promote your plan? How will you communicate with your staff and also with people with disabilities and impairments? Will you publish it? If so, in what format? Will it be accessible? Will you publish your performance? And if you do, in what context and when? How will you work with your board to ensure that all of this is communicated and clear and that your goals and targets are reported on? The key here is about making sure that your accessibility action plan is real, it's lived, and it's questioned and challenged and communicated to all. So going back to the example of the case studies around Disability Australia, it has a communication section that is in there, and this is an example of the screenshot, which, as I mentioned before, has a hyperlink in it. And what you could do, and giving you examples of how to promote your plan, how you might publish it, and how you might think about the performance against your plan. So what about implementation? We've talked about it, we've communicated about it, we have clear targets. Who's going to be responsible for ensuring that the goals and targets are done and achieved, and in what time frame? Who will monitor the progress? Or who will talk to staff and ensure that it's included within their plans also? Who is accountable for the performance against the plan? Again, referencing the case study, here's a couple of great examples, and again, interactive around who will be responsible, the monitoring, the goals, and how you ensure the accountability. We have a second case study, again from Australia, this time the Opera House. I've used Australia twice here as they have really good accessibility examples, and it's been in place for quite some time. I also like the opening here with the Opera House. I'm just going to read that through. The Opera House belongs to everyone. As an organisation, our goal is to provide barrier-free access, making the site, the building, and the experiences accessible to all people. Often when we talk about accessibility, people just think about ramps, maybe lifts or, rails and the physical impact. Here it's very clear that they're talking about the experience, and we'll have a look a little bit further about what that might mean. Again, the hyperlink is in here so that you can go and have a look and use as many of these examples as possible to help you build your own. So what about the evaluation? This is a good example that they had here. How are you going to implement your goals and how will they be monitored? How will you review the progress? How will you ensure it's up to date and it's relevant, which will be key as the market changes and new products are made more available? What would the process look like? And what will you do should a grievance procedure or a complaint come in about discrimination with disability? This second case study also has some really great examples of what an evaluation may look like. We want to be clear that these evaluations often have sort of short, medium or long term, i.e. you don't have to achieve the desired result immediately. The clear thing here is to show that you've made some considerations. You're thinking about what you can do to remove barriers and how you can do it. Again, this is really useful should a claim happen for yourselves and you can show your thinking. In this example, I've only taken one of them, and that's the building. They've clearly outlined what they said they would do and what the key deliverables achieved are. Making sure you're evaluating in this detail really helps ensure that everybody knows what your goals are, what you've achieved, and how you're going to move forward. What else could it cover? And then some local tips. We've given some great case studies all online. Locally, we have information, including digital and web, customer experience examples, physical access, and policies and procedures. We have a number of partners that we work with in Guernsey, some of which are in the UK, such as Purple Tuesday, Accessable and CAE, the Centre of Accessible Environments. Let's take a look at some of their tips. Accessibility for printed documents. So here is an example, and with the hyperlink, of a guide that has been produced by the States of Guernsey. If you have any other questions on this, the States of Guernsey has a disability officer, and you can also check this out on Signpost or the gov.gg website. What about web design? Again, there's a States of Guernsey document on how to make your website more accessible. We also have web accessibility tips, and the same with producing digital content through a partner called Purple Tuesday. Purple Tuesday is available on the website if you join as a partner for free, and in effect it gives you access to all of its resources. We'd recommend that everybody has a look at this, as their tips and guidance have been exceptionally useful over the last few years. Again, with customer service, I mentioned Purple Tuesday, which's campaign is to improve the customer experience for disabled people. We've partnered with them for the last 5 or 6 years and have found them extremely useful. They have tips on how to help, things like disability, etiquette and wording, and also tips around customer service. Another local organisation that can help on this is the Guernsey Employment Trust. What about some tips on accessibility for buildings? Again, there's Purple Tuesday and some local examples. Here we've listed a couple of things that you may need to think about. It's not just about getting around or into the building, but how did you get there in the first place? How do you enter the building? But also, even before that, what was the signposting like to get to parking? Could you find the location itself? Was it easy to locate? Can everyone access all areas of the building? And are the staff trained to help where necessary? Again, on the State's website, there's a couple of examples of documents that are available to support you through this process. I've listed a few here with the hyperlinks: arriving at the building, inside the building, moving around inside the building, and means of escape. These are all available on the State's website, gov.gg. Another document, or a number of documents that are available through the States, I think are really useful and worth taking a look at to understand more about what you may wish to do, or again, nothing wrong in stealing good examples, is the Business Disability Forum, one of the partners of the States and ourselves, who were commissioned in 2017 to do some audits for the States of Guernsey. These are all available on Gov through the hyperlink here, and shows out the audits and the action plans that were done for the committees for the States of Guernsey. We also work with a local training provider that I mentioned earlier, CAE, the Centre for Accessible Environments. We've had a fantastic take up in the last couple of years with CAE, and we run 1 or 2 courses a year. In the course, which is a 2-day programme, people are taught or spent time doing practical work around access auditing. This is really important to ensure that everybody from builders, designers, architects, facilities managers, anybody that is involved in accessibility around building structures, but also customer service, etc., takes part in a uniform programme, so that when we work together in Guernsey, we can ensure that everything is accessible as possible. So far, we've trained nearly 60 access auditors in Guernsey, a few in Alderney, and even a couple in Jersey. The next courses are available for the following few years by contacting info@disabilityalliance.org.gg. There is also on that website a great video about what the course is about and some testimonials. What about policies and procedures? Well, the new Equal Employment, Equal Opportunities Service, the EEOS, will provide information and signposting in the next couple of months. So that's in the year 2023. The states of Guernsey will also be publishing guidance notes to explain the new legislation, the duties organisations will have under it, and again, providing you as much feedback and support as possible. So our last question is around, is there any accessibility duty relating to roads? Yes, there is. And the states of Guernsey is under that duty in relation to persons with disabilities and how we consider how we map our public highways and make them more accessible. Access for All and the Guernsey Disability Alliance and the State's Disability Officer have been working with highways for a good number of years now and have encouraged with them to consider constructing, altering and repairing the road surfaces. So, for example, considering crossings, dropped curves, etc. This only applies to the states of Guernsey. I'm now going to pass you over to Sarah, who will talk through enforcement.
Thanks, Karen. So I'm now going to move on and cover enforcement. So looking first at the initial notification of complaint. Now, it's important to note here that this is only required if the claim is against a provider of goods or services, a provider of education, a provider of accommodation, or a club or association. So it's not in an employment context. Now, this initial notification of complaint must notify the person who the complaint is about within 6 weeks of the act complained of. This complaint must be in writing, and the person must state that if the potential complaint is not resolved within 1 month, that they may exercise their right to make the complaint under the ordinance. So it's really important, looking at those timescales, if a complaint is received, that you act promptly to try and resolve it before matters become more formal. 6 weeks is obviously quite a short time frame. And one other point to note is that we are likely to see some guidance for what needs to be included in these types of complaint. Now, just one thing, a small thing to flag. Obviously, I've mentioned this is not a requirement in the employment context, but if you are an employer, the likelihood is that you will receive some form of initial notification, but likely to be in the form of, for example, a grievance. So there usually is an opportunity to try and resolve matters informally before moving on to the more formal processes that we'll come on to cover now. I just want to touch first on pre-complaint conciliation, because before filing a claim, the complainant must notify the Employment and Equal Opportunity Service, who will then give both parties the chance to engage in pre-complaint conciliation. Now, in order for pre-complaint conciliation to run, clearly both parties need to be amenable to that and be prepared to try and conciliate. And this does give an opportunity to try and resolve matters before they become more formal. And as you can see from the slide, if pre-complaint conciliation does not result in an agreement between the parties, the individual can progress to raise a formal complaint. And I'm going to move on now to consider the formal time limits now. So, looking at the time limits, a complaint must normally be presented within a period of 3 months of the act complained of. However, it is important to note that any period of conciliation will not count towards this time limit. And what that means is if the period of 3 months has started rolling and say a month in, both parties agree to start engaging in pre-complaint conciliation, the clock essentially pauses. And there is also provision that if that pre-complaint conciliation process happens further down the line into the 3 months, there is provision that if that then unfortunately does not resolve matters and a formal complaint and the conciliation breaks down and a formal complaint is looking likely, that the person will have at least 1 month of time to be able to put forward a formal complaint. The tribunal also has the discretion to extend the 3 month time limit. And this could be extended where the tribunal is satisfied that it was not reasonably practicable for the complaint to be presented within 3 months, or that it's just and equitable to extend that time. Of course, it's important also to note that there is potential for post-claim conciliation at any point up to the tribunal hearing. If someone wishes to bring a claim before the tribunal, they will need to raise their complaint to the secretary of the tribunal using the appropriate form, and those forms will be accessible online, but also from the Employment and Equal Opportunity Service. Now, the complainant must have complied with the pre-claim formalities set out on the previous slides that I've covered in advance of filing any formal complaint. And if a settlement or a compromise agreement has been signed, then the tribunal will not hear the case. If, having gone through a hearing and a judgment being given, either party is dissatisfied and they have grounds for appeal, potential appeals will be made to the Royal Court and thereafter to the Court of Appeal. Now, moving on now to financial remedies. First of all, I'm going to look at claims for failure to comply with the reactive duty. And just to note that this is except for claims that may be brought against an accommodation provider for failure to make or allow physical changes to premises. So, first of all, looking at the reactive duty, the financial remedy here would be up to 6 months' pay or up to 9 months' pay if the person succeeds in more than one complaint relating to the same facts and circumstances. Now, as you can see, the wording there says up to, so there will be some discretion there available to the tribunal in terms of when they are determining what award to give. In addition, there would also be up to £10,000 for injury to feelings, hurt or distress. Now, the injury to feelings award, that will be banded, and those bands will be set out in regulations, which are still to be confirmed, but there will be 3 bands, a lower, middle and upper band. So again, the tribunal will have some discretion as to the level of award that it wishes to give in those circumstances, if appropriate. Now, that will be the financial remedy unless this method of calculation would be inappropriate, for example, because the complainant is not paid by the respondent, and in which case compensation would be up to £10,000 for financial loss, if there are any financial losses in the situation, and an additional award of up to £10,000 for injury to feelings, hurt or distress. And as mentioned again, the same language here, so up to, so there's a discretionary element, and we would again see those same bands for the injury to feelings and hurt or distress award. I'm now going to move on and cover financial remedies for claims for failure to comply with the proactive duty. And as we've covered earlier, that proactive duty is relevant for service providers, schools and education providers. In this situation, if a successful claim is brought, financial losses of up to £10,000 may be awarded. In addition, up to £10,000 for injury to feelings, hurt or distress may also be awarded. I've covered what that type of award may be, and again we see that language of up to, so the tribunal will have some discretion in terms of the level of award that is given. In addition, there are some non-financial remedies that can also be awarded in some circumstances. So, for example, an order to make a reasonable adjustment may be given. And finally, the last point on the slide, I just want to note that this is the only remedy available for breach by an accommodation provider of its duties to make or allow physical changes to premises.